My lord, before the list is called on, my lord, I have a tearing urgency, my lord. The pressing urgency is, my lord, this matter relates to post-poll violence, my lord. My lord, my wife was the pradhan of the gram, my lord. Now your lordship knows, my lord, since the, my lord, the boot is on the other foot, my lord. I had a threat perception. Where is why, my lord? My lord, there are three, my lord, armed force constables were, my lord, deployed. Now they have withdrawn one yesterday. Now they are going to withdraw today, my lord. I was shot at earlier, my lord. There was an FIR, but I was the victim. Now, my lord, unless I get protection, my lord.
Highly, all matters are taken up. You serve notice.
My only difficulty is that, my lord, from today, my lord, afternoon, I'll be absolutely without any protection, my lord. So I am there, my lord.
It will come as per presentation form. All matters are.
Well, if it may appear tomorrow, my lord, I'll give tomorrow's date.
No, day after tomorrow, you know there is a.
But then day after tomorrow, it will come, my lord.
Whom I will give direction. Tell me, Mr. Bhattacharya.
Unless the leave is granted, I think it will take some time.
File it, you indicate in the presentation form, as per presentation form, it will appear. To whom I will give direction, unless and the state is represented.
But only, my lord, unless some direction is passed, your lordship understands, my lord.
File my lord, as per presentation form.
I may not remain alive, my lord, for pressing this application.
No preference is required now. All matters are called on.
But, my lord, post-poll violence matters, my lord, your lordship understands, my lord.
Matters will be called on. You file it as per presentation form.
Well, I'll do that. Well, only
ensure presence of.
I'm obliged. Well, only difficulty is that your lordship is aware of, subject to correction by your lordship.
At the same time, also appreciate the difficulty court is facing.
No, absolutely, my lord. This is my life threat, my lord, which is why I am before your lordship. Yes. Unless leave is granted, my lord, they will not give number before 48 hours, my lord. Only if that leave is granted, my lord.
Let it come up after 48 hours.
Perfect, my lord. So, my lord, for that I require the leave, my lord.
No, sorry. Yes, please call.
My lord, may I be permitted to mention one non-prosecution matter? Non-prosecution.
Mention on Monday. Today is not the mentioning date. Those which are very urgent matters, like Mr. Bhattacharya has mentioned, mention on Monday. I have refused others. Mention on Monday. I will allow your mention.
Non-prosecution matter.
My lord has. Yesterday you mentioned.
Yesterday I have mentioned, my lord.
Mentioned on Monday.
My lord, service has already been.
Very well. Mention on Monday.
This is only non-prosecution.
Mention on Monday. Mention on Monday. Non-prosecution. Don't. Try to invite attention of this court since it is non-prosecution. I will allow your mentioning, but not today. I have refused others. Mention on Monday, I will allow.
Your lordship, seeking leave to file one matter. Your lordship, petitioner is a victim of sexual offense. Petitioner residing in state of Madhya Pradesh. Now she wants
file it.
Your lordship, difficulty is that she wants to file through the representative, and the signature of the petitioner is not available in the prayer portion. Only that difficulty is.
That how can I do?
There is all formalities done. I only want leave to file. That
no, that how can it be? It has to be under the procedure.
Your lordship, because the accused person bail was rejected, he is absconding, and I want for better investigation.
Accused person is the petitioner?
No.
Then ask her to come.
She is in Madhya Pradesh.
Sorry.
Item number 1. This is an assigned matter, lordship, secondary returnable by death come returnable benefits. The lordship, your lordship has direct lordship extensively heard, and lordship, there is a direction for filing a report. Now, lordship, report has been delivered to us. Now, lordship, her ladyship, please to release this matter.
Just a minute.
Reception storage. Reception আছে ফাইল করেছি
Matter needs hearing in presence of the state respondents, because there is a direction upon the district inspector of schools to
File a report. Report has been delivered to me.
But the other side presence
Yes,
is
yes, Lordship,
required.
that is correct. Lordship,
Will you
kindly, only one line order, Lordship, I am
Just,
praying.
just a minute.
Lordship, I am praying for a file to exceptions to the report. Report has been.
No, not at this stage. Uh, uh, m- matter has come up in the list under the heading to be mentioned. On being assigned, video order dated 18th November 2025 by the Honorable the Chief Justice. Stop. Today, petitioner is represented by learned advocates, but respondents are not represented. Stop. List the matter under the heading motion assigned in the monthly combined list of June 2026. Stop. Next paragraph. In the meantime, learned advocate representing the petitioner is directed to take steps for ensuring representation on behalf of state respondents and the school authorities. Serve notice, let the situation is changed, and then some of the matters will come under the heading assigned motion. Then I will try to accommodate those matters. Next.
Item number 2, Your Lordship, I am appearing for the private respondent. The matter went in appeal at our instance, and the Honorable Chief Justice, sitting with Justice Shen, was pleased to send the matter on remand.
So remand matter, Milo.
Remand.
Mention this matter.
Internally, if Your Lordship
Just a minute.
give the copy. আচ্ছা, Joseph, please copy. এটা তো তুমি প্যারা লিখে বসে আছো।
Paragraph 26 of the Honorable Division Bench judgment, Milo.
লিখে দাও ওটা।
So let the affidavit be exchanged.
Yes,
You are representing whom?
the private respondent in the writ petition, the club.
I am the writ petitioner. Milo.
Relief was sought against my client, where the Honorable Single Judge Justice Ghosh was pleased to held that I am a trespasser. Against
You are
that of
representing 7 and 8.
5 and 6.
You are representing 7 and 8.
Lord, Mr. Iftekhar Munshi, the landlord. The pro
Then you
forma
have to serve
respondent.
notice upon 7 and 8.
My lord, I have informed him. He called me, Lord.
Where is the notice upon 7 and 8? You mentioned this matter.
My lord,
5 and 6.
I have already intimated.
I will be praying, my
Lord,
lord.
today morning, Mr. Munshi informed me, my lord, due to some personal difficulty, he could not present here. My lord.
My lord, 2 weeks time to file affidavit, my lord, in opposition.
No, who is representing respondent number 7 and 8?
My lord, Mr. Iftekhar Munshi.
Iftekhar Munshi, my lord.
Where is he? Where is he?
My lord, he personally requested me, my lord, that he is unable to, my lord, appear today. My lord, I will
Till
intimate.
tomorrow. Come back tomorrow.
Very well.
Issue.
That is zero.
List the matter under the same heading tomorrow, comma. May 2026 for further consideration. Since you are representing respondent number 5 and 6.
Yes, my lord.
Since apart from respondent numbers 5 and 6, other respondents are not represented. Stop. Next paragraph. Learned advocate representing the petitioner is directed to inform the learned advocates representing non-appearing respondents. Stop. Come back, let me see.
My lord.
Why can?
My lord, can at our instance, my lord, that is for appropriate order, but let the affidavits may be exchanged, my lord. Thereafter, your lordship may be pleased to hear, my lord. That is for opening of the padlock, which has been put by the police, treating my client as trespasser in the said premises. So I am not.
But
my
my
lord,
specific
can.
case,
What you are praying for in can
my lord,
application?
can is for appropriate order, so that the padlock may be reopened. But I
So that
so that the padlock may be removed by the police.
it's an allegation
Because
of criminal
Let
trespass.
me finish, sir. The earlier, my lord, when the writ petition was filed, at the instance of the writ petition, an allegation was that I am a trespasser, and that was held by the Honorable Single Judge. Against that, we preferred the appeal, where the Honorable Chief Justice, Sitting with Justice Chain, was pleased to hold that we are not trespasser, and the issue has to be decided.
you
finally
preferred
by-
appeal.
I prefer appeal. Grateful, madam. So I am not pressing now this.
You took the point that without serving notice, matter was heard by
I
the
took
single,
the point, my lord,
by the coordinate bench.
My lord, I took the point, my lord, that without giving me the opportunity to file affidavit, my lord, the order was passed. And in a writ.
Why you did not represent it before the coordinate bench on 25th September 2025?
But
My
they
lord,
represent-
no, it was represented, but
They appeared, my lord.
they appeared, my lord. Some
Lord, this
set
is
of
the-
lawyers are
Lord,
other.
may I hand over the copy of the order of the coordinate bench?
Just no, it is on record.
But my lord, no affidavit in
The
spite of.
matter
my
was remanded only, my lord, because of the point, my lord, the
Not only, my lord. My lord, I stand correct.
You are
your lordship.
representing 5 and 6.
Yes. Of
Lord,
the-
Mr. if
Lord,
Iftikhar
if you
Munshi is
will
appearing
kindly-
virtually. my lord.
Respondent number 5 was represented, but not 6.
Yes. Yes.
So you took the point before the coordinate bench
Right. No.
Not at
that
all.
time I was.
that
not-
you want to file affidavit.
My lord, that time. My
Where is
lord,
the recording in the order of the coordinate bench?
My lord, that was the instructions I received from my lord.
Where is the recording in the order of the coordinate
My lord,
bench
I
that you
don't
prayed for accommodation to file affidavit
lord,
in opposition?
Grateful
My
to
lord, I don't appear, my lord, earlier before the honorable coordinate bench. Some other set of lawyers appear. For the first time, I am.
Can it be a ground?
My lord, that was.
Can it be a ground for
My lord,
taking this point that though I took the point of I prayed for accommodation to file affidavit in opposition, same was not considered by the coordinate
My
bench?
lord, that was taken by the honorable Chief Justice. If your lordship kindly sees, my lord, paragraph 20 onwards.
Court is asking, court has seen that order.
Yes. My lord,
Where is the point taken before the
my
coordinate
lord, that was not recorded, but that was asked for. That is my instructions from my client, my lord. I don't appear before the honorable single judge. This is the first time I am appearing in appeal. Only I am beseeching your lordship.
change of advocate will absorb the responsibility?
No, not only that, my lord. Apart
It
from,
appears so prima facie.
my lord, apart from that, my lord, the point of trespasser was observed by the honorable single judge in a writ jurisdiction, which has to be adjudicated by a civil court, whether I am trespasser or not. Kindly see, my lord, paragraph 20 onwards, subject to correction from your lordship.
We'll come back tomorrow.
My lord, Mr. Iftikhar Munshi is appearing, my lord.
Very well, you try to serve notice, come back tomorrow.
Grateful.
Very well, Madam.
Item number 3.
State is not represented, state's representation is required. State has to be given opportunity to file affidavit.
My lord, so far
In
as, my
terms
lord,
of the order of
present
the division
situation
bench.
is concerned, my lord,
My
the erstwhile
Yes,
state
what is the matter
administration
about?
not appearing.
Next matter.
On item number 3, my lord, I am for the petitioner. Lordship may kindly sees two orders, 25/3/26 and 4/5/26.
Why it has come under the
My
heading
lord,
to be
it has
mentioned?
come under the heading, my lord, since the matter has been compromised between the parties and has been settled. So that is why your lordship had kept it, my lord, on the 4th of May, my lord, since your lordship had asked me to.
ইডি ভুল ম্যাটারে দাঁড়াচ্ছে দাদা না তুমি ইডি তে কি
Who is appearing for the respondents?
Private respondents, my lord, they are appealing.
Settled out of court. Yes.
না নেই
Learned advocates representing the petitioner and you are representing 8. State is not represented.
State will not be required, my lord. Now matter has been settled.
আমাকে instruction দিয়েছে যে
ইডি কো
party নেই।
কে দিচ্ছে প্রাইভেট লিস্ট কে সিনিয়র
Learned advocates representing the petitioner and respondent number 8. have jointly submitted that the issue involved in this writ petition was settled out of court. Next paragraph. In view of such submission made on behalf of the parties, on behalf of the petitioner and respondent number 8 court, no further order need be passed on this writ petition and same stands disposed of. And the writ petition stands disposed of. Parties to act on the server copy.
Or the affidavit of service be kept with the record. Since you are not
The affidavit of service filed on behalf of the petitioner is taken on record.
Item number 4.
The petitioner, but last occasion your lord called for further report and went to the state. State already filed a report and I filed my lord exception. My lord, I'm led by Mr. Bhattacharya.
Where is Mr. Bhattacharya?
Yes, he's not available.
Very well. You are there. Just in. Any report by the Commissioner of Police?
At that time, earlier occasion, they filed one report and today state, my lord. not available.
last occasion, there.
Ask him what is his designation.
Legal case, on legal case.
But how long you will park your vehicles on national highway? Because it's a tenancy dispute. You approach the civil court, obtain an order, but court will not grant you indefinite protection for parking your vehicle on national highway. Remove those vehicles now.
Already, my lord, I tried my best to see, but
No.
that finishes.
Considering the exigency, I have protected you, but that will not continue for an indefinite
my lord,
period.
I file my exception. My lord, first of all, the police started a case under section, my lord.
So, unless and until this criminal prosecution is concluded, you will park your vehicle on national highway.
No, my lord.
Then
Already, my lord, I have tried my best to, my lord, remove my vehicle. Already.
in
my
the
lord,
meantime,
started.
you may remove a vehicles
But
now.
my
You have
lord,
got the
that, my
protection by 7 days. But after that, authorities will be at liberty to levy fine
my
and
lord,
fine.
Lord, but my first prayer, my lord, illegally, my lord, in
That court will consider in presence of the learned advocate who will represent the state respondents,
Right.
but no further protection with regard to charging.
Well, in the
fees.
meantime, my lord, you kindly fix the date, 7 days after 7 days, and in the meantime,
Matter will be posted after vacation, but within 7 days you remove your vehicles. No further protection. Enough is enough.
my lord,
No.
I have no fault, my lord.
I have granted you this
Yes,
protection for a
that's
long period,
Right.
but for this, if this criminal prosecution and tenancy dispute will persist for an indefinite period, that does not mean
No,
it will grant you or confer you a right to park your vehicles on national highway.
Certainly
That
not,
this
my lord.
court is not going to permit you further.
Well, certainly not, my lord.
Yes,
Kindly-
all on a sudden, this allegation was that you are evicted from your premises without due process of law. Considering that aspect, court granted you that relief, but this is for a temporary period, not for an indefinite period.
But that is true, my lord. But
So remove your vehicle by 7 days, failing which?
instead of 7 days, my lord, 2 weeks. My lord.
No,
My lord,
No.
2 weeks. But otherwise, my lord,
no.
there's so many vehicles, my lord. Not
Uh,
only one or two vehicles, my lord. They are
Matter is
restricted
taken
vehicle,
up
my
for
lord.
consideration.
In presence
uh,
of the police, my lord.
Matter is taken up for consideration in presence of the learned advocates representing the petitioner, and respondent numbers 4 and 5. Who is
4 and-
representing respondent number 6?
4 and 5.
Respondent numbers 4 and 5.
And 6 is the Upapradhan.
However, state respondents are not represented. Upapradhan will not appear now. However, state is represented. Stop. Next paragraph. In view, considering absence of learned advocate representing the state respondents, hearing of this matter stands urgent. List the matter under the same heading for further consideration on 9th June 2026.
Vacation, my lord.
No, sorry, 9 June 2026.
Then, my lord,
Stop.
action date, my lord.
However,
Yeah, sorry,
however, petitioner is directed to remove vehicles which are parked on National Highway 16 by 7 days from date, failing which concerned respondent authorities are at liberty to take steps in accordance with law.
Instead of, my lord, 15 days, my lord, otherwise, my lord, 7
In accordance with law, since it is found that that criminal prosecution has already criminal prosecution was initiated, being Lilua Police Station case number 46/2026 under section 180 of Bharatiya Nagorik Suraksha Samhita 2023 and investigation 2023. Stop. Furthermore, disputes relates. Furthermore, there is a tenancy dispute in between the petitioner and your client, in between the petitioner and respondent number 4 and 5. 4 and 5, for which petitioner is required to approach civil court in pursuit of remedy. Stop.
my lord, instead of 7 days.
No.
Otherwise, my lord,
Huh?
exception came
No,
in
no,
the
exception. Exception. But I have not granted you to file any exception.
file report. They started a case under section 370.
I have not granted you leave to file any exception. Very well, exception filed on behalf of the petitioner to the earlier report filed on behalf of the concerned police authorities taken on record. Next.
9 June.
Approach the civil court, get an order under order 39 1 and 2.
Already ousted, my
This
lord.
court cannot pass such order. Yes.
Item number 5.
Item number 5, my lord, in this matter, Mr. Sujoy Bandyopadhyay appearing for the petitioner. Can it be fixed, my lord, at
What is the urgency?
At 2 p.m.?
No,
No,
my lord.
what is the urgency?
I do. I am not engaged in this brief, my lord.
At the time of call, accommodation is paid for on behalf of the petitioner. However, private respondents are represented by learned advocate. Advocates of hearing of this matter stands adjourned. list the matter under the same heading for further consideration on 17 June 2026. আর একটা line add করো, learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state learned advocate representing the petitioner is directed to petitioner বা petitioners কি আছে দেখে নেবে, is directed to take steps ensuring presence on behalf of the state respondents. Next.
Appearance. Item number 6.
Lordship, I have to- My lords, may kindly.
Just a minute.
Lordship, I apologize. Order sheet. আমরা যে চিঠিটা দিয়েছিলাম এক্ষুনি করছে এগুলোটাই। Election.
You are representing officer in charge.
My lord, ad hoc arrangement, my lord, because
Then in all such matters, there will be a direction for personal appearance.
my lord,
In order to avoid the difficulty which court is facing. How long this will continue?
my lord, we have, I assure,
See our position.
my lord, I.
All matters are being adjourned, and what will happen after
With
vacation?
folded hands, my lord, will kindly appreciate that we will come out with flying colors next week. We will not do any, my lord, we have done, my lord. The shopper group,
Then in all matters, I am going to pass an order directing failing which
I am
the
always
concerned
at my lord's
state
command.
respondent shall appear in person.
My lord will not do that. My lord, I am. at my
Otherwise,
lord's beck and-
petitioner, learned advocates represent the petitioners are lamenting every day
My lord
due
will
to
kind-
absence of the state
my lord
respondents.
will kindly appreciate. I am at my lord's beck and call. My lord's order is my command. But my lord, what has happened, my lord? I assure your lordship, as my lord's officer, that within next week, my lord, everything will be in order.
Otherwise, court is not in a position to function.
What is happening, my lord? My lord will kindly, I will try to take my 30 seconds of my.
Yes, yes.
Because of this reason, my lord,
Nowadays, courts are having time to hear the
ample time,
learned
lordship.
advocates
My lord, this has been.
beyond the prescribed time.
This has been told to me by many of the honorable judges of my lord's coordinator, be it the criminal benches for specifically, my lord, as far as my lord Justice Joy Singh Gupta is concerned, one amicus curiae has been appointed. And the same is happening with my lord Justice Tirthankar Ghosh. And my lord, just the honorable division bench of my lord Justice Banerjee, my lord, that is also saving. And my lord is the worst sufferer. And same is my lord Justice Hiranmay Bhattacharya because of the land. So, my lord, wherever, but my lord, we have we are doing the needful, my lord. I assure as my lord's officer, things will be in order from Monday, if not later than that, my lord. But
At least just before vacation,
my lord,
court can function. It's a very urgent determination.
my lord.
Otherwise,
That is
lordship,
happening, my lord, because today these matters, my lord, because of some gap of communication on the last occasion, report was ready of my officers, but it could not be filed before my lord. So, my lord, and those and now my officers also suffering. They have come, though there was no direction for person.
Now I understand that in which matters state respondents' presence can be ensured,
My lord,
and court will take care of it.
even at the cost of repetition, my lord, I am at my lord's beck and call. I am roaming here and there in various courts. My lord will
Well,
just
court
summon.
is appointing Mr. Trivedi, senior advocate, as amicus curiae
My lord will kindly just ask.
in all matters
No,
from 10:30 to 4:30.
my lord will kindly not do that. But my lord, I assure as my lord's officer that any time, at any part of the day, my lord may summon me. I will be here within 5 minutes and I shall do the needful so that the state does not cut us sorry.
Do this, otherwise
My lord, we are
there is a real
My
difficulty.
lord,
court
my
is
lord,
facing.
we have already.
Nobody is representing.
So, my lord, this has been taken up by.
And in this determination,
Yes.
state's presence is
Yes,
required.
yes, yes.
It is not it is not a determination where court is hearing the cases of respective cases of petitioner and statutory bodies.
And my lords have been very kind also, especially my lord, because from the time
there was a change of dispensation.
But that will not cut any eyes
I know,
now, since you are appearing today.
My lord, but now, my lord, we have more or less settled it, my lord. So, my lord,
Yes.
yes, my lord. Lordships, my lord, the direction passed by my lord, we have prepared a report, my lord, which was supposed to be filed on the last occasion, but due to some miscommunication, lordships will kindly, एक second. No problem. My lord will not take as a miss, my lord. Just for my lord's, perusal, we have flagged it. My lord will not take me amiss. We don't mark copy. So, my lord, here, my lord, we have categorically submitted before your lordship that, my lord, we have taken all proactive steps. There, my lord will kindly, I will give a recapitulation of what the matter is. The petitioner before your lordship had made certain complaints of apprehension of being assaulted by the accused persons. Now, by the accused persons of an FIR. Subsequently, there too, he was assaulted. A case was registered by us. Thereafter, my lord, we made all searches, everything, but these people who have assaulted, they are absconding. We have taken steps and we have, in accordance with law. In the meantime, the petitioner made another complaint with regard to his apprehension, further apprehension. We have taken steps with regard to that. In the meantime, one of the accused persons had come to court with a plea for anticipatory bail. That has been rejected. We had opposed it, that has been rejected. Now, lordships, we are taking all proactive steps to apprehend him. The report is having all those documents annexed to it. If my lord,
What is the present stage of investigation?
my lords will kindly, my lord will
This is
kindly.
an Iqbalpur police station case number 48, 28 February 2026
Lordship.
under section 109(16)(61) Bharat BNS. Now, what is the present stage of investigation?
Lordship will kindly see, my lord will 1 to 1, my lord. Initially, the present stage is, my lord, that we are taking all proactive steps to arrest, apprehend these accused persons. If my lord kindly takes up the last page of my report.
Paragraph 6.
Lordship,
Just a minute.
I apologize. At
where is your complaint?
Page 3, my lord, we have stated specifically what.
Where is your complaint? Page 24.
Lordship will kindly.
P3, page 18 to 27 of my petition. চিঠিটা মেল করে পাঠানো হয়েছিল সাত্বিকের মেল থেকে, ওটা প্রিন্ট আউট রাখতে বলেছিলাম। No, not this one. কার্তিক কোথায়? যে মেলগুলো পাঠিয়েছিল সেখানে 164 মেল প্রিন্ট আউটটা বলেছিলাম।
Where is the injury report?
Lordship,
Where is the injury report?
Lordship, there is a case of specific case of older 307, now 109, and pursuant to learned court bureau has already observed all this during the hearing of anticipatory bail and was pleased to pass this order. And Lordship,
Just a minute. Try to arrest him
Lordship,
and file a further report.
my lords will kindly appreciate.
Because the anticipatory bail has been rejected, so the accused is required to be nabbed.
My lord, my lord, paragraph 3, Lordship, we have said that we have taken, my lord.
Lordship, my learned friend may be directed to submit a copy.
Matter is heard in presence of the learned advocates representing the petitioner.
My lord, my officer in charge is here. He is assuring, he has just joined. He is assuring, Lordship, will not record it, but my lord, we will, my lord.
What to be not recorded?
No, my lord, I'm saying, my lord, that my officer in charge has just joined newly, my lord. So we are taking steps, my lord, all proactive.
In presence of the learned advocate representing the petitioner and state respondents, Mr. Trivedi?
My lord, state respondents.
State respondents?
Yes.
And state respondents. Stop.
My lord, as far as I'm
Learned
concerned
senior,
today, my lord,
Mr.
I am
Kirat
only
Trivedi, learned
representing, my
senior
lord, the Calcutta Police, my lord, because there's a special notification with Calcutta Police, my lord, that they can appoint without, my lord, the permit from the legal members. So, my lord, as of now, my lord, I am just representing, my lord, the police authorities. That is 2, 3, 4, 5, 6, 7. Means apart from 1. 2 to 7, my lord.
Very learned advocates representing the petitioner and respondent numbers 2 to 7.
Lordships.
Stop. In terms of the previous order passed by this court, a report dated 30th April 2026 of officer in charge Iqbalpur Police Station, Kolkata is placed before this court and same is taken on record. Stop. Let this report be, let copy of this report be made over to the learned advocate.
My lord, I'm sorry,
representing
my lord.
the petitioner.
Grateful.
Next paragraph. It is disclosed in the report dated 30th April 2026 that based on the complaint lodged by the petitioner, a criminal prosecution being Iqbalpur Police Station case number 48 dated 28 February 2026 was registered under section 109 within bracket 1 slash comma 61 within bracket 2 of BNS read with certain provisions of Arms Act 1959. Stop. It is submitted by the learned senior advocate it is submitted on behalf of the police authorities on behalf of the police authorities that investigation is going on. Stop. It is stop. It further appears from the said report dated 30th April 2026 that accused moved an anticipatory accused moved a pre-arrest bail application which was rejected by the learned session judge at Alipur. Stop. Next paragraph. Considering the allegation made by the petitioner against the accused person, court directs inspector in charge Iqbalpur Police Station being respondent number 5 to take necessary steps for apprehending the accused person within a reasonable time. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on. 17 June 2026.
I'm grateful, Lordships.
Stop on the next date. Respondent number 6 shall file a further report.
And Lordship, only one rectification subject to correction of your Lordship. There will be accused person. There are two accused. One has not pressed the case. Another's bill has been rejected. Both has filed the bill application. So there are two accused. There are two private respondents. Your Lordship has stated accused
Let them
person.
take steps.
I'm grateful, Lordships.
Grateful.
My lords.
Item number 7.
For the petitioner.
What is the urgency?
Actually, the petitioner is a tenant in respect of a
Yes,
shop,
petitioner is a tenant.
in respect of a shop room. And the private respondent had broken the padlock of the shop room and taken possession without due
The
process.
property dispute come back after vacation in the monthly list. Issue. At the time of call, state respondents are at the time of call, though petitioner is represented, however, state respondents are not represented. List the matter under the heading motion in the monthly combined list of June 2026.
Your Lordship, please it
No,
not in-
property dispute come back
supplemented
after vacation in the monthly list.
Item number 8.
I'm for the petitioner.
Who is for the petitioner?
I'm for the
What is the urgency?
Lord, urgency is it's a police in action case, my lord.
Yes, all are police in action cases.
Kindly see.
What is the urgency?
Kindly come to page. This will reveal the urgency. Kindly page 19.
What is the urgency? Tell me.
In spite of having the injunction or order
By the civil court.
the
Monthly list of June. Come back monthly list of June.
they are raising construction money.
Yes, yes. Property dispute, civil court case is pending. Come monthly list of June.
My lord, order is there. Injunction
Yes, yes.
order is there.
Next matter.
Item number 9.
Your Lordship, I'm appearing for the petitioner.
But you are asking for a passover. You are asking for a passover.
Same thing.
No, Lordship. Lordship, we have done. My lord, will kindly take my report. Lordship, what has happened is one person we have arrested, she has been remanded to custody.
When arrested?
Yes. And the other person is here.
When arrested, Mr. Trivedi?
Lordship will kindly come to the second page of my report, my lord.
Just a minute.
Lordships. করেন নি সি করে দিয়েছিল পরে কি করে এটা এ আছে এটা সি সি কোথায় বি হলো
Money was transferred for by following what procedure? Is it
Yeah.
cyber fraud?
No, Your Lordship, I had willingly given the money
For what?
because we had a cordial family relation. She was my sister-in-law, and since my wife had passed very early, and I am an aged person, I relied upon few family members, among whom these were the people.
Case. 318 BNS.
We have also
15.
given
Well, steps have been taken. One has been arrested. It was detected that in account of two other accused persons, some was credited, and the bank authorities were directed by the police authority to debit freeze their account. So therefore, let me dispose of this writ petition, directing the police authority to take necessary steps to conclude the investigation in accordance with law at an early date. Matter is heard in presence of the learned advocates representing the petitioner and state and police authorities.
May I take my lord's leave if my lord
Mr. Trivedi, now court will.
My lord, I am always at my lord's beck and call, my lord.
In
more than happy,
matters.
but
Yes.
my lord will. I assure my lord that things will. Be
Mr. Trivedi, on behalf of the petitioner and concerned police authorities. Stop.
with my lord's leave.
Yes. Directed to take steps for it. In terms of the order dated 21st April 2026, a report, a communication dated 11th May 2026 of officer in charge Netaji Nagar Police Station, Kolkata, is placed before this court and same is taken on record. Stop. Copy of the said report dated 11th May 2026 is made over to the learned advocate representing the petitioner. Next paragraph. It is disclosed in the communication dated 11th May 2026 that in connection with Netaji Nagar Police Station case number 193 dated 29th August 2025, one accused person was arrested on 10th May 2026, and subsequently, in terms of the order of the court below, he was remanded in police custody till 14th May 2026. Stop. It was also detected by the concerned police authority, or it was also detected by the investigating agency that sum was credited to the account of two other persons, and concerned bank authorities were directed to debit freeze respective bank accounts of those two accused persons. Stop. Next paragraph. On perusal of the report dated, on perusal of the communication dated 11th May 2026, it appears certain steps have been taken by the concerned police authorities in connection with the aforesaid criminal prosecution. Stop. Next paragraph. Concerned police authority is directed to take the investigation to its logical conclusion at an early date and submit a report before the jurisdictional magistrate. Next paragraph. writ petition stands disposed of. However, this order shall not preclude the petitioner to approach the jurisdictional magistrate if a situation so arises in future.
Gratefully, Your Lordship.
Item number 10.
My lord, this is that matter, my lord, where my lord directed, my lord, to the state, the respondent number 4 directed to provide necessary assistance to the prisoner which would permit them to stay in their aforesaid residence, because petitioners are the senior citizen. What happened, my lord? After passing of this order, I made a formal representation to the concerned authority that I am willing to return back to my home. They went along with me, and what happened? The private respondent, using unparliamentary word, and my lord, forced me to, my lord, not allowing me to enter my own residence. And my lord, and also my lord said that we are not bound by the High Court's order.
Now, in terms of the order dated 21st April 2026, you are the son and daughter-in-law. Petitioner has been taken to his residence and he is staying there.
No, my lord. No. Because, my lord, I am not able to enter my room because he is using unparliamentary and not allowing
In front
me.
of police authority.
Yes, in front of police authority, my lord. My lord, in front of
Police did not arrest them.
No.
So you are staying. Why you did so?
That is the fact which my learned senior is saying, that is not true. The day before yesterday, police came along with these petitioners, and the petitioner disclosed before the police that from yesterday they will want to stay
my
on
lord.
that property.
I have talked to the.
Allow him to make submission.
Pardon me, my lord. Pardon me.
What is going on?
Pardon me.
Yes.
My lord, I clean the property. I purchase groceries products for them. Then since yesterday, my lord, they disclosed that they want to stay in the property. But till today, my lord, I took instruction from the client. No one is going there. Neither the petitioners, not father. I am very much willing to stay with them. The property is first floor. They are.
I want a report from the police authority because both are the parties who are at loggerhead. So therefore, court should not rely upon the submissions unless something or any report comes from the police authority. So let it be adjourned. Hearing of this matter stands. Hearing of this matter stands adjourned till 15 June 2026, in order to enable the concerned police authority or in order to enable the inspector in charge, Asansol within bracket South, close bracket police station, to submit report. Stop. Come back.
Great.
Give your appearances.
I'm praying for my lord unconditional apology.
Item number 11.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph, in order to grant one more opportunity to the petitioner, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 19th May 2026.
Item number 12.
In this matter, advocate for the petitioner, Mr. Santosh Kumar Chakraborty, seriously ill, my lord.
Seriously ill.
Kindly
At the
adjourn
time
this
of
matter
call,
for
accommodation is prayed for on behalf of the
weeks,
petitioner since
at
learned
least 2
advocate is unwell. Stop. Hearing of this matter stands adjourned. List the matter under the heading motion in the monthly combined list of July 2026. Next paragraph, learned advocate for the petitioners is directed to serve notice upon the respondents by 1 week after ensuing summer vacation and file affidavit of service on the next date.
Item number 13.
My lord, I am for the petitioner in item number 13. My lord, in this matter, the land has been grabbed in this way, my lord. 8 deed has been registered on a single day without me being going to the registry office. Somebody else has gone there and registered the executed the deed, my lord, in person. And the description of the deeds have been given in my lord, paragraph number, page number 4 and 5.
We are praying for registering of FIR.
Yes, my lord.
So that is not permissible. You have to approach under 175(3) BNSS.
My lord,
It's an alternative remedy. This
my lord,
court
this
will
is
not
an
permit
alternative.
this court to convert into a magistrate court.
My lord, I understand, my lord, but I have gone to the my lord, police station several times. What is happening exactly, my lord? I am telling your lordship. My lord, the complaints have
On
been
hearing the
refused.
learned advocate,
My lord, the complaints have been refused on several occasions.
appears
All the envelopes are
placed
here, my
for
lord. The
direction
complaints
upon
have
the
been
concerned
refused.
police authority to register FIR based on the complaint lodged. Stop. Next paragraph. There is availability of alternative remedy under section 175 of Bharatiya Nagorik Suraksha Samhita 2023. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007-6 SCC 171 within bracket Aliu Padamsi and others versus Union of India and others. Next paragraph. Hence, writ petition is not entertained and same is dismissed. Stop.
My
Next,
lord, this
however,
honorable court has
this
ample
order,
power to, my lord, kindly
however,
order
this
for the
order shall
registration of
not
the
permit
FIR,
the
my lord.
however,
Kindly,
this
my lord.
order shall not preclude the petitioner to approach the jurisdictional magistrate in pursuit of remedy.
My lord, the FIR, I have already gone personally and then they have refused it, my lord.
Next matter.
The posts have been also refused, my
Yes.
lord. No, they are not listening.
Item number 14.
Approach the jurisdictional magistrate. For that, writ jurisdiction should not be invoked. Yes.
Advocate on advocate on record,
Yes.
clerk asking for an adjournment, lordship, for 1 day.
At the time of call, accommodation is for the petitioner.
Lordship, for the petition.
At the time of call, accommodation is prayed for on behalf of the petitioner. Stop. Hearing of this matter stands adjourned. Stop. List the matter under the heading motion in the monthly combined list of July 2026. Stop. Learned advocate for the petitioner is directed to serve notice upon all the respondents by 1 week after ensuing summer vacation and file affidavit of service on the next date.
Item number 15.
Item number 15.
Yes.
State respondent mistakenly not served it, lordship. Kindly give the direction, and other services are also not complete.
Monthly list of June. Monthly list of June, simply. No. Sorry.
So kindly give a direction to serve copy to the state. Unless this direction is given, they will not.
আচ্ছা তাহলে দাও তো দেখি ফাইলটা রেকর্ডটা at the time of call learned advocate representing the petitioner prays for accommodation to file to serve notice upon the respondents. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the respondents including the state respondents by 10 days from date and file affidavit of service on the next date. List the matter under the heading motion in the monthly combined list of June 2026. Next.
Item number 16.
16 on behalf of the private
agency. You are for?
Private respondent number 5
What
and
is the
6.
urgency?
My lord, the urgency is this: private respondent has illegally vandalized my home, two-storied mud house, I made a representation to the OC of Nandakumar police station. Then I appeared before the superintendent of police, but no action has been yet taken.
What action you are praying for? Registering of FIR?
No, my lord, I am praying for the police protection, my lord, because I want to stay into my own house.
Civil suit is pending. Interim injunction vacated. Thereafter preferred appeal. This is pending before the learned ADJ. This is my homestead act, my lord. This is my homestead land, my lord.
My lord, I have also got the land from the homestead part, my lord. My father has got it, and in his lifetime, he has made the house, my lord.
But where you have prayed for extending protection by the police authority? Where is the prayer? Only prayer to take steps on the basis of your complaint.
This is the
That
order.
means registering of FIR. Where is your prayer for granting protection? Come to prayer, page 10, prayer A.
My lord.
Consider and dispose of the petitioner's application. This is the prayer. I could understand that if you have prayed for a direction upon the concerned police authorities to provide security, safety and security by deputing police personnel. Where is such prayer?
Then grant me liberty, my lord.
Liberty cannot be granted for amending the prayer.
Then kindly ask.
Appears from the prayer that you are praying for a direction upon the police authority to register your FIR. That is not permissible by filing a writ petition under Article 226. So therefore, you approach the jurisdictional magistrate and raise your grievance. If your complaint is unattended.
My lord, can I get a interim relief, my lord, because I want to stay into my own house, my lord.
On hearing the learned advocates representing the petitioner, and you are representing respondent number
5 and 6.
5 and 6. That grievance of the petitioner is inaction on the part of the police authority in taking steps based on the complaint lodged by the petitioner. Stop. In other words, prayer is made in the. In other words, petitioner has prayed for direction upon the concerned police authorities to register an FIR. Next paragraph. There is an alternative remedy available to the next paragraph. There is an alternative remedy available to the petitioner under section 175 within bracket 3 of Bharatiya Nagorik Suraksha Samhita by approaching the Bharatiya Nagorik Suraksha Samhita 2023 by approaching the jurisdictional magistrate. Stop. In this regard, reliance is placed on the judgment of Aleu Padamsi Korediyo. Next paragraph. Hence, writ petition is not entertained and same is dismissed. Next paragraph. However, this order shall not preclude the petitioner to approach the jurisdictional magistrate in pursuit of remedy. Take it back. Take it back.
Item number 17.
I am for the petitioner.
But I am appearing.
What is the urgency?
The petitioner is the owner of a plot of land. I purchased the plot.
Month list, June, serve notice, property dispute, come back.
And next one is also same on the property dispute.
Monthly list of June.
Item number 18.
Let it be called on. Item number?
Malad, I'm appearing.
Item number 18.
Number 5 and 6.
18 হয়ে গেল monthly list of June. Then call item number 19.
Item number 19.
Or stated or
State, anybody is appearing?
Malad, state is not appearing.
You are appearing in 17 and 18. Both are to appear in the monthly list of June. Then 19, yes.
18, I'm appearing for respondent number 5 and 6.
18.
18.
Monthly list of June, come back.
Mine.
Yes, item number 19. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. In order to grant one more opportunity to the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 20th May 2026. Next.
Item number 20.
This is my application. This is my.
What is the urgency?
My lord, there is a civil dispute. My lord.
Month list of June. Serve notice. No order.
Item number 21.
I am for the petitioner.
Urgency.
Our petitioner is a victim of POCSO case. The FIR has been registered.
Item number 22.
Yes. Who is for the petitioner? You are for the state.
Private estate, private estate.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondent numbers 11. 11 is represented by learned advocate. Next paragraph. Hearing of this matter, in order to grant one more opportunity to the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 20th May 2026.
Item number 23.
At the time of call, no one appears for the petitioners and no accommodation is paid for. However, paid for. Hearing of this, in order to grant one more opportunity to the petitioners, hearing of this matter stands adjourned.
This is a comprehensive writ petition filed by the writ petitioner against the port, against diverse police stations where properties are secured. Now, two things are there. Service not completed, and second, the state is also cannot represent.
Then come back after vacation.
Yes,
Let it
after
be in the monthly list of June.
After vacation, any date can leak.
Why? What is the urgency?
Urgency is that many properties are locked.
Yes, property.
I have Port Trust has received the eviction order. Now, in spite of the eviction,
civil court
from the estate officer.
Estate officers.
From the estate officer. Now, the Lordship knows Port Trust is the largest landlord in the state.
Now you are seeking a direction upon the police authority for execution of
multiple
order of the estate officer.
Multiple orders. It's a huge land is locked. Without police assistance, we cannot.
Quarters are there.
Yes. Some there are.
So then you have to serve notice upon the persons who have occupied this land.
That I will do, because most of the cases,
where the parties are represented, where are the parties who have encroached the land in question?
That I will satisfy your lordship later. Kindly, take the matter in the month of June. Any day convenient to your lordship. Any day convenient to your lordship.
When the order was passed by the estate officer?
There are different orders.
Yes. What was the last order?
That I have to see. Today service is not completed. That is why I am.
Estate officer, yes, please come back. Please come to page 147, 18 January 2021.
Yes, these evictions order, there are multiple.
So what is the urgency? So 2021 order, you are coming in 2026.
There are total 111 orders.
Yes, last order is 20. Prior order, Previous orders are dated of 2018.
Yes, Lordship is absolutely.
At the time of call, Mr. Nag, learned advocate representing the state, representing Shama Prasad Mukherjee Port, representing Shama Prasad Mukherjee Port, being the petitioner, comma, has prayed for accommodation to effect service of notice upon the respondents. Stop. Hearing of this matter stands adjourned. Learned advocate for the petitioner is directed to serve notice upon the respondents by 2 weeks after ensuing summer vacation and file affidavit of service on the next date. List the matter under the heading motion in the monthly combined list of July 2026.
July will be too late.
Then you have to serve notice by 10 days.
That I can
time.
That I can do.
Very well. 2 weeks to 10 days karo, June 2026.
I'm grateful. Grateful.
Last order is 2021, Mr.
I know, my lord. I tell you,
and prior order started from 2008.
I know, my lord. Lordship, what happens? There are 111 orders. That is, my lord, we could not do anything, my lord. So much public area is now occupied. That is the problem.
আচ্ছা বলে দেবে 3টের সময় যেটা ফিক্স আছে ওটায় বসবো একটু শুনে নেবো।
3 p.m. fixed matter, item number 24.
I have already completed my submission. Lordship asked me to take instruction regarding that Bhumika Singh's matter. That is still pending, Lordship.
Yes, just a minute.
সিঙ্গেল বেঞ্চ জাজমেন্টটা কবে ছিল? এই তো বলে ফেব্রুয়ারি।
Yes, what you are submitting?
Lordship asked me to take instruction for the Bhumika Singh's matter, whether any other order has been passed or not. The matter is still pending. The only order which I have placed before your Lordship.
Later, so far this court is concerned.
Yes.
To dispose of this matter.
Yes, Lordship. And Lordship, one thing, I have indicated the date, which was a later date. These are the letters we have received numbers of vacancies.
That is, you have disclosed in your affidavit. They have High Court administration has disclosed.
Yes. Still, I have given Lordship the letters.
এটা কোথায় গেল?
This is not required.
Lordship.
এই এটা মালিক বাজার সুলতানটা বার করো।
Because we have initiated the proceedings,
না না মালিক বাজার
recruitment process on the basis of these two letters which were disclosed in the affidavit of High Court administration. Page 15, page 14 and page 15. So far page 14 is concerned, it is in relation to WBJS examination 2023. First letter was issued on 27 June 2023. It stood modified with a subsequent letter dated 19th October 2023. And another letter is dated 5th March 2025 in relation to WBJS examination 2024, which in this regard, first letter was issued on 19th April 2024, which stood modified with a letter dated 5th March 2025.
Yes, Lordship. Only in the chart I have written.
Based on which you acted upon.
Yes, Lordship. Only on the chart I have written a wrong date, Lordship. It would be 14 November 24. On the basis we have published the indicative exam advertisement.
14 November?
14 November 24. Lordship can keep this corrected chart.
Just a minute. Yes, in this chart, which date is it?
The column dates maintained by the Commission for 2024. First page, Lordship.
First page, advertisement 19/2023.
Lordship, dates maintained by the Commission for 2024. It would be 14 November 24.
There is a West Bengal Judicial Service Examination 2023.
24.
24.
24.
24, there is no such.
In the same chart, it is written, Lordship. By mistake, I have written 2nd April 25.
Received on 2nd April.
It would be 14 November 24, Lordship.
জাজমেন্টটা এখানে ওটা আছে দেখো। পেজ 4 all judges.
Second April should be 14 November.
14 November 24.
The delay in notifying the vacancy.
Yes.
By Malik Bazar could not be followed. These are things.
Yes, what is your submission?
One is, due to COVID, there was a substantial delay, in 2020 and subsequent notification, and then, Ivana Hosseini and the other two petitions, the recruitment process was stalled. That is.
Yes. Yes.
My lord, may I proceed?
No, you have to give reply.
Yes. And
only with regard to their submissions.
Yes.
Else.
I have noted their submission. I'll be giving.
No fresh submission.
No fresh submission. I will only just counter their submissions because they have stated certain things.
No new submission, Mr. Lahiri.
No new submission.
Yes.
But they have quoted certain provisions of the rules also. My lord, first, may I just, my first humble submission before your lordship is this, that paragraph 9 of Roman 9 of paragraph 89 was discussed, that initiated
May
by
2025
right, initiated by the High Court. That was the contention extensively, that High Court had initiated, so initiation of PSC will not be the issue, initiation of the High Court. That was unanimously submitted by the respondents. Now, my lord, kindly take Malik Maza Sultan paragraph 5, which recognizes two types of recruitment process, one conducted by the High Court, another conducted by the Public Service Commission, both. Paragraph 5 at page 705.
Yes, paragraph 5.
5. Lord, may I just place it before your lordship?
Are you submitting that Supreme Court was not aware of this difference?
No, my submission is it cannot be the contention of the Honorable Supreme Court that it is only applicable to the
Supreme Court was aware of this.
That is my submission.
In spite of that, this direction was given.
My humble submission is that Supreme Court was aware of this, that it is conducted by both the High Court and the PSC.
Still, this direction was given.
It has been used as a generic expression. That it does not mean we cannot read paragraph Roman 9 excluding the recruitment to be conducted by the PSCs. Initiated by High Court is a generic observation made by the Honorable Supreme Court. Therefore, my lord, if it is read in other way, it would be contrary to Malik Maza Sultan itself. It cannot be. Just the line I'm reading, one line, it says,
paragraph 5. Yes.
Paragraph 5, placitum F, my lord. We may, however, note that progressively the authorities concerned would consider, discuss, and eventually may arrive at a consensus that the selection process be conducted.
Placitum.
F G onwards. F G onwards.
Page 705.
705.
Yes, yes.
Eventually may arrive at a consensus that.
Just a minute. Yes, yes. G, placitum G.
Yes, my lord, placitum G. Discuss and eventually.
We may, however, note that.
We may, however, note that progressively the authorities concerned would consider, discuss, and eventually may arrive at a consensus that the selection process be conducted by the High Court itself or by the Public Service Commission under the control and supervision of the High Court. This is very important. Under the control and supervision of the High Court. So it was never the contention of the paragraph.
Please read subsequent.
Yes, yes. Reference can be made to the decision taken in a conference held between the Chief Justices and the Chief Ministers, minutes whereof show that in some of the states, selection of subordinate judicial officers at all levels of civil judges is already being made by the High Courts. Some states where selection is still being made by the Public Service Commission, we are agreeable to entrust the selection to the High Courts, whereas Chief Ministers of Himachal Pradesh, West Bengal, Punjab and Kerala were of the view that the present system may continue. But the decision taken jointly was that in the said states, Himachal Pradesh, West Bengal, Punjab and Kerala, setting up of question papers and evaluation of answer sheets be entrusted to the High Court. Further decision taken was that in other states where selection of subordinate judicial officers is not being done by the High Courts.
So not only it is to be forwarded, but in the question papers and everything is to said by the High Court and it is corrected by the.
It is a proposal. It is to be done.
No, this is done.
Yes.
This is in effect done.
Yes. My respectful submission before Lordship is that two types of system.
You may not be aware of that these question papers are said
I know
by the
that.
High Court.
I know that.
And these are answer scripts are corrected by the High Court.
Yes, yes, I know that, my lord. I am aware of it.
So not only this notification of vacancies is to be forwarded. There are other roles
performed by the High Court. So it
played, but in the present case, that is not relevant.
That is not relevant.
We are concerned with regard to initiation of process.
Now initiation. Now this initiation, if it is initiated, it is conducted by the High Court. It is to be initiated as per the High Court's documents. If it is conducted by the Public Service Commission, the law is well settled. Initiation is from the date of advertisement.
That you have submitted.
No, that is why if we read these two paragraphs, it will go contrary. It was never the intention of the Honorable Supreme Court in paragraph Roman 9 to exclude the recruitment process conducted by PS.
Paragraph 89.9 of the judgment dated 20th May 2025, Supreme Court did not make any distinction in between two
That is my submission.
different types of
That is my
proceedings,
submission.
selection process. Rather,
Yes.
Supreme Court directed the High Court.
High Court, that is in generic sense. It is not that excluding the public service commissions. Now, the initiation, if it is done by the public service commission, that is from the
Any
date of
other
that-
point?
Yes, I have other points, my lord. Kindly allow me. Because
Yes.
they have stated certain rules and
No,
regulations.
no,
and
I have given you enough time. Today you are
the
on
rules
reply.
were
I will
submitted.
not permit you to make any further
I'm
new
not
submission.
making, I'm
Yes.
replying. They have given rule
Yes,
4,
yes,
8.
this
I
is
need
over.
to-
Next
yes,
point.
this is one. So
Next point.
it cannot be read in contradiction.
Yes.
So it was generically, it was applied.
yes, yes.
One. Second, my lord, kindly appreciates the rule of 2004, which was relied upon by learned friends. Kindly take rule 4A of the 2004 rules. West Bengal Judicial Conditions of Service Rules 2004. 4A, first time placing, that was mentioned. Appointing authority means the governor and includes the authority empowered to make appointment to the post which a judicial officer for the timing holds or to the grade of the service in which the said officer is for the timing
For
included.
that rule 4, you need not read.
I am coming,
You
madam.
should
Kindly
read-
allow.
You should read Article 234.
I am coming. I have not.
No, no, it's not a new case. I am hearing you
I am
for a long
not.
period of time. Don't be precise.
I'm
Because
being-
this is not required. If you read Rule 34, it says the
I have
same
seen
thing,
it. I
that the appointing authority is the governor.
just allow me, my lord. I'm just because these rules were raised by them. I did not raise this. Kindly take paragraph 28 for once. Rule 28 for once. 28. What is the status of the High Court? 28(1), sub-rule 1. Appointing authority. All appointments to the post as referred to in clause A of subclause B 1 shall be made by the governor in accordance with the recommendations of the High Court. So High Court is the recommend.
Read Article 234.
I have
Same thing is read. There is nothing significant in this rule.
I'm saying why it's significant. The recommending High Court, the nature of High Court
That is
the
also
recommending.
stated in Article
Yes.
234.
Yes, it says
In
as per the pleasure
consultation
of the
with
governor.
in consultation with the High Court and the state government,
Very well, madam.
judicial department.
The High Court is only recommending authority.
Yes.
It does not initiates. It's only recommends as per the
Yes,
rule
any
itself.
other thing.
Yes. It's getting difficult.
No, no, you have made elaborate submission.
I need
have
to
told
respond.
you.
Man, it's such a
The
huge
reply
matter.
You should be precise.
It's such a huge matter, my lord. I need to
No.
be specific on that. My lord, kindly
It's
take
not
the
a very huge matter. I have heard it
Please,
for
my lord.
quite some time. It's not very.
My lord, kindly take the affidavit.
Matter which requires 100 days hearing. Yes.
No, I'm not saying 100 days, my lord.
Yes.
Kindly take. Then Malik Mazhar Sultan, paragraph D. That
You have placed it.
No. Well, this way it is getting very difficult.
You have
for me
placed
to-
it. I have
not placing
during
something
course
new.
of submission. You have relied upon Malik Mazhar. Now you have relied upon. And I have this paragraph 5. I have considered paragraph 70. I have
Repeating
considered.
my submission, I'm saying why? Because they have submitted, they have read differently, Malik Mazhar. Kindly allows me, at least, my lord, kindly appreciates my predicament.
Anything with regard to their submission. What difference
am
they have? They have
showing-
stated
I have to be-
that in paragraph 5 there is a difference with regard to initiation of selection process.
I'm not
So for
showing
High
that.
Court and other court is concerned, 70.
My lord
What
is
are the steps
prejudging
are
my
required to be
submission.
taken?
I'm not submitting even that. Kindly appreciates, allows me to make my submission. Paragraph D1 says
15 minutes. I have said last occasion, not more
well,
than
in
that.
this 15 minutes I am being, they have submitted your
Yes,
lordship,
yes.
kindly
I have allowed you more than everybody.
I need to respond to that.
15 minutes. Yes.
This
Yes.
is
Yes.
my lord, kindly come to very well. 15 minutes allows me to make my
Yes.
submission.
Already 16. 316.
They have
Yes.
submitted.
Yes.
Paragraph 1D1, page 709. Kindly take my lord, Malik Mazhar Sultan.
Yes. What does it say?
Number of vacancies to be notified by the High Court. It is to be notified. Now, my lord, kindly take their affidavit. The document I am placing before lordship. Kindly see the kindly page 14 of the affidavit submitted.
Of their affidavit, High Court's affidavit.
This is yes, my lord.
Yes.
High Court's affidavit. Page 14. Based upon which there was so much of deliberation that High
Yes.
Court initiated. My
Yes.
lord, kindly see. It is not in consonance with Malik Mazhar Sultan because this is not notification of vacancies. Kindly see, my lord. Subject. First of all, it is an departmental document from the registrar to the principal.
I have
secretary.
seen these documents at least on 5 occasions. Please tell me what you
15
want to
minutes
submit.
kindly
Don't
allows
place
me-
it. What you want to submit.
That's what I'm trying to submit.
Yes, you need not read this document. I have
I
seen
need to
this
show, my lord, this way. At
Yes,
least
what you
15
want to
minutes
submit,
uninterrupted
what you
15
want to
minutes.
submit on this document.
I'm
Tell me.
submitting that.
Yes, don't read it. Read
Correct.
this.
Kindly see the subject, reporting of revised. This is only reporting of vacancies. This is not notification of vacancies as
Very
per it says kindly see the second paragraph. Vacancies in total number 23 clear.
I have read this document at least on 5 occasions. Please don't read it. So according to, this is not a notification, but reporting of vacancies.
It is says it is to be notified.
Yes.
So this date cannot be taken.
Yes, yes. Anything more?
This date cannot,
Very well.
it says it is to be notified in the cadre.
Yes, I have heard you. Anything more?
It is not in consonance with paragraph 1.
Third point.
15 minutes
Second
kindly
point is-
allows me, my lord,
Yes,
15 minutes.
Third point.
The next, also the 2004, it also said it will be confirmed and be reported. So this is not in terms of 1D1 of Malik Mazhar Sultan, which says vacancies to be notified. This is
Right.
not notification. This is an interdepartmental communication which says it's only a reporting. It is not notification.
Don't repeat
So
your
these
speech,
dates,
so
these dates do not come in the way.
Very
These
well.
dates cannot be taken into
Yes,
consideration.
yes. Anything more?
So far, the judgment of Tej Prakash Pathak, which was stated that it is under 229 and it is not 234. Even if we take into consideration for the timing, we consider that the judgment is not applicable in the case. In that case, the AP versus Sarat Chandra comes in my aid. It is also was done by the Public Service Commission. That was under.
But AP versus Sarat Chandra was considered in subsequent judgment of.
Yes, I have checked that. I'm submitting.
Subsequent judgment that I have indicated you.
Kodamtala.
That
Pavan Singh. Yes, I have.
Pawan Pratap Singh.
Pavan Pratap Singh, I have
Yes.
considered. What I am submitting, that this
It
distinction.
depends upon the nature of recruitment rules.
What I am submitting.
Yes.
Tej Prakash Pathak, 7 judges bench has laid down the principles.
5 judges.
I'm sorry, 5 judges bench has laid down the principles. These principles cannot be applied separately for 229 or 234. It is a generic, complete guideline. It cannot be said just because it is under 229, these guidelines will be followed, but for 234, these guidelines will not be followed. That initiation would not be from the date of advertisement. If
Irrespective of 229
or 234, these principles applies. Moreover, for the timing, if we consider their submission is to be correct, then AP versus Sharat Chandra, it is specifically observes that it is the initiation point is the date of advertisement, which was done by the Public Service Commission, and this comes under 234. Next, my lord.
New submission, I will not disturb you. But that should be confined to their submission. But those documents you have placed it, other side has placed it, nothing more to be read.
Document can be read in different ways, my lord,
Yes.
after hearing their submission.
But that not in reply.
I'm not responding.
Yes, that not in reply, Mr. Laidi. You should not have any grievance with regard to the opportunity. Which
No,
is
I'm not.
granted.
At least reply.
Yes,
At the reply
that is not
stage.
in reply.
At the reply
In
stage.
reply, you are not required. You are not. You will not be permitted to open a new case.
The way they submitted, I need to
yes,
respond to that.
Any other, yes,
I have,
after
my
Tej
lord.
Prakash.
Now, my lord kindly appreciates the Public Service Commission. If lordship kindly takes the advertisement for once. They stated why this indicative advertisement was issued. My lord, kindly take page 30 of the writ petition. It was submitted, a novel submission.
I have read it. Yes. Yes, you submit. You make submissions. Not request to be.
It says no age. This was pointed out by them. I did not point it out. I need to
That
respond.
reconciles with the date of indicative advertisement.
No, that is my submission. It says not less than 23 years and not more than 35 years on the date of advertisement, not indicative advertisement.
That was clarified subsequently on 23rd of August 2025.
Yes, this clarification comes subsequently.
Yes, not subsequently. 15th of August, 23rd of August. See
Yes.
the clarification.
Yes, it is after the indicative vacancy. This is after this main advertisement.
After the main advertisement, main
subsequent.
advertisement on 15th of August.
Yes.
Clarification was on 23rd of August.
23rd of August.
Yes.
So subsequently, that's
It
what
was
I'm submitting.
clarified.
So they said that it is the not less than from the date of advertisement, and they reckon to the
clarification.
Yes, I've seen. I'm submitting that. Now
So that has been clarified.
They are referring to the advertisement. They are not saying indicative advertisement. If you lordship kindly take the trouble.
That point you have taken. Yes.
I did not take this point, my lord. I did not have the opportunity.
On advertisement, you have taken it entire day.
No, I am submitting their
Yes.
submission.
Anything more? Anything more?
Submission করবে? It's
Yes.
not possible. Explain it. কি করবো বলো? And in their affidavit, they say that this indicative advertisement is a prelude to the advertisement. This prelude, I can show you, possibly lordship will not go into that, I do not know, but they said in their affidavit that it is the prelude to the advertisement. There is no concept of prelude to the advertisement in the eye of law. Nowhere in the service jurisprudence, prelude to an advertisement is not recognized. I can show from their paragraphs, they have stated. If your lordship so wishes, I can place
No,
it.
it's not
I
required.
need
You
not
have
to.
made submission
Very.
on this point.
This prelude.
Yes, on this point you may have forgotten, but you
No,
have made submission.
Maybe, my lord.
That it is nothing indicative advertisement dated 15th of August to be reckoned with for the purpose of initiation of discipline.
Submitting prelude, they have stated in their affidavit, prelude is not the prelude cannot be done.
Yes, that is what you are
I have understood,
clamoring
my lord.
for a long period of time.
Possibly not. I beg to
Yes,
differ, my lord.
yes.
Lastly, my lord, since there was no point in making any other submissions, since my lord, so far the point that whether the petitioner why did not participate.
Indicative advertisement is not prelude to main advertisement.
No, I am saying there is no concept of prelude to the advertisement. There has to be advertisement, no prelude. A previous some sort of document.
Which is impermissible.
Which is impermissible.
Yes.
Prelude there is no prelude to the advertisement.
Yes. Yes.
Last, my lord, the point that why it had fallen from your lordship, because obviously I could not raise this point for your lordship. Your lordship said, and even the PSC also submitted that why did not he participate? What is the bar? He could have participated, and then now, my lord, I'm squarely covered by the Supreme Court judgment which says it acts as an estoppel for me.
Today that you will not
I have
be permitted.
I have given
Because in the interim order I have indicated this. Today I will not permit you to rely upon any judgment.
I have given
New
the
judgment.
copies
Because
previous.
in that event I have to grant them opportunity.
I have given previously copies to them.
No.
In advance.
You have not made submissions before this court. I have taken detailed note.
Yes, they have also submitted.
No, I will
an
not permit you,
response.
Mr. Lahiri.
Very well, my lord.
Because I have refused interim order on certain grounds. One of the ground which is that you are an eligible candidate.
Very well.
In spite of that, you are given enough detailed opportunity to make submissions. Then you did not take point. So now, in reply, if I permit you to rely upon the judgment, then I have to give them opportunity to deal with the judgment. That this court will not certainly.
Then kindly considers my oral submission.
Yes.
That the law is well settled. That it acts as an estoppel if a candidate participates knowing the condition and then challenges it. It's acts as an
That
estoppel.
point you have taken from the very beginning. That if I would have participated in the selection process, I would be stopped from raising.
Knowing the condition that 3 years is
That you
not
have
there.
taken.
So the initial stand of my locus on that point I
That
submit.
you have taken.
Yes, for that there I'm not
At the
listening.
motion stage also you did take, and during the hearing, final hearing also you have taken.
Yes, that these are the Supreme Court judgments. I'm not sincere.
Don't rely upon any Supreme Court judgment
This is my
today.
Today, very well, no
reply.
problem. Kindly appreciates my submission, considers my submission. It acts as an estoppel, knowing the condition. If I had not known, then it would come.
That you have taken.
Yes.
On query to you raised by this court, you took this point that if I would have participated in that event, I would have stopped from challenging this.
They would have said that you are an unsuccessful candidate. You understood.
Yes.
Then you are
After participation.
You realize that you did not fare well in the examination.
You don't have the authority to challenge.
Challenge because you have understood that you are not succeeded properly, or you have not given a good examination. Now you are coming and challenging.
Yes.
So on that pretext plus estoppel.
Yes.
That I'll be stopped knowing the condition. And so far the delay is concerned, my lord, that the timeline I have found out, there was no subject to correction by my lord. Yes, their delay. They have
that point you have not taken in your petition.
They submitted why there was a delay in that.
That is not your issue. That court asked them. You have not agitated this point by it's a point of fact, point on fact.
During
you have not stated in the
yes, during argument.
So therefore, you are not required to deal with it.
During argument,
I asked them
yes,
that why Malik Maza Sultan was not followed.
Yes.
Then they answered today that these are the points. But that is not the case made out in the writ petition. This is the point on fact. Today you are
arguing this point.
In absence of any averment in the writ petition, don't try to expand.
I'm not trying to expand. I do not know whether this point will go against me or not. But since it came up during the argument,
this point was not perhaps known to the petitioner because this Malik Maza Sultan was indicated by this court.
Yes. Absolutely. That's the only thing that since during argument this came up. This says the single bench judgment was dismissed on 18th of March 2025. So
It is
initially,
not an issue before this court because you have not raised this issue on
no,
fact.
it is for
So
them.
please don't make any
Very well.
submission in reply.
Very well.
Yes. Had this point been taken in the writ petition, I could
No,
understand.
I had no scope to take this point. এত কিছু বলার নেই। ওটা তো আদার স্টেটটা তো রেকর্ড করে নিয়েছে, এত কিছু বলার নেই। মানে these are my respectful submission.
Most of the point you have touched in while addressing this court at the time of hearing.
This
So only
point is
if
very
in reply
important,
you have
my
to
lord.
add something which must be connected to their reply, not beyond
Their
that.
reply, they have
But at the same time, you are also uh, uh, no, you will not be permitted to take the point on factual aspect when in the writ petition those facts are not agitated.
No, I'm not taking. I mean, only on the point that they have said that it is a reporting of it is not even. It is to be notified.
Yes, that you have stated.
Yes, in terms of Malik Mazhar D1. So that I had
It's not
to
a
take.
reporting of
It
vacancy.
is not reporting. It is an interdepartmental. That is my respectful submission.
So according to you, what should be the reporting of vacancy?
Like all other states, they perform. There is a specific notification coming to reporting
What
of.
notification?
It comes that these are the vacancies available for this post. It comes in that fashion.
I am trying to ascertain from you that what should be the appropriate notification.
In public domain, their notification is there. Notification comes that these are the vacancies.
Notification in what form?
Notification.
This is being done for a quite long period of time.
No, I would have realized if the High Court issued a communication or any authority that these are the
It's not a
vacancies.
communication of High Court.
It says otherwise, the reporting. It is not. It is not.
What should be the appropriate reporting?
In terms of Malik Mazhar
Registrar
Sultan,
General was communicating
it's an
to the
interdepartmental.
department,
Malik
principal secretary, judicial department. What should be the appropriate notification in that event?
What modalities they would follow, it is their decision. I cannot enter into that. But as per Malik Mazhar Sultan, it clearly says number of vacancies to be notified by the High Court.
Why it is to be found? It is being found that it is not a notification in terms of 7D, paragraph 7D
D1.
of Malik Mazhar.
D1. It
Paragraph
says
7D. What are the features of this?
Yes.
Other features which are required to be there in the notification?
It says, firstly, number of vacancies to be notified by the High Court. First of all, this is not at all a notification. It's an interdepartmental communication. Subject is.
Registrar General is writing to the principal secretary
Kindly takes the
government of West
subject.
Bengal
Kindly takes the
and
subject.
stating that I'm not saying all these things since you are in reply, stating this into account 23 clear and 31 anticipated vacancies anticipated to occur in the year 2023. 54 vacancies total may be
notified
in the cadre of civil judge.
May be notified. So this is not notification.
May instead be notified.
Yes.
Why? There was a previous notification dated 27 June 2023, which stood modified by subsequent notification dated 19th
So the
October
final vacancy ought to have been notified.
So it is a notification for the purpose of filling up the posts of civil judge junior division.
But the subject
That is
says
the usual practice.
reporting of revised number of vacancy. It's a reporting between one department to another. Subject
Has been pleased to direct that taking into account 23 clear and 31 anticipated to occur in the year 2023, 54 vacancies in total may instead be notified.
Be notified, my lord. It is to be notified.
Notified means in the advertisement it is to be notified.
And this was never in public domain.
In the advertisement it is to be notified. Not from the High Court side.
So your lordship is
from the end of High Court, it is the final notification. Why this amendment was required? Because due to influx of time, there might be certain vacancies arose. So in order to club all the vacancies in connection with 2023 selection process, this modified vacancies were required to be issued.
1 That is
What
my
further
humble
notification is required to be issued?
In public domain, there is no vacancy notification. Your lordship is saying it in the
Public
final
domain.
advertisement, it should come in that case, according to lordship. But my respectful submission.
Notification of vacancy or vacancies are to be notified in the advertisement that these are the tentative vacancies, these are the anticipated vacancies, and these are the clear vacancies.
Then in that case, my submission stands that it starts from the actual advertisement, not any interdepartmental document.
But this is a notification in terms of 7D.
But in terms
no
of
other, no further notification is required to be issued as per norms.
in terms of Renu and Amrit Yadav, it is like specific. It starts from the advertisement. Even AP versus Sharat Chandra, that it starts from the advertisement, not from this. This is my respectful submission.
Hearing concluded, judgment reserved.
Gratefully, lordship. Much obliged to lordship.
Grateful, madam.
এটা করে পাঠিয়ে দিন।
No, I'm 15 minutes, not more than that. No. I will grateful, your lordship granted us so much of time.